The addition of genetic information discrimination to the EEOC's mandate is historic and represents the first legislative expansion of the EEOC's jurisdiction since the Americans with Disabilities Act was enacted in 1990, almost 20 years ago. The Genetic Information Non-Discrimination Act was passed with overwhelming bipartisan support by a vote of 95-0 in the Senate and 414-1 in the House. We welcome the opportunity to implement important provisions of this landmark act and to expand the promise of equal opportunity in the workplace for all Americans. The notice of proposed rulemaking before us today is already a well-traveled document. Significant efforts were expended by our attorneys in the Office of Legal Counsel last summer and fall drafting this document, which the Commission approved in the fall of 2008 under the leadership of then-Chair Earp. After we approved the document, we sent it to OMB for interagency review. The document came back from OMB earlier this year with relatively minor changes, and last week the Commission voted unanimously to approve this NPRM. Our goal for today's meeting is to call attention to this NPRM and to invite and encourage vigorous review and comment on this document. We look forward to obtaining feedback on this document from stakeholders throughout the public comment process so that we may issue our final rule, which by statute we are asked to do no later than May 21st, 2009. We do so with the benefit of rigorous review and comment from the public. We look forward to your comments. Mr. Gruber?
Good morning. Thank you for inviting me to speak with you today. My name is Jeremy Gruber. I'm the President and Executive Director of the Council for Responsible Genetics, until quite recently the Legal Director of the National Work Rights Institute, a member of the Pew Working Group on GINA, and a founder and Executive Committee member of the Coalition for Genetic Fairness. When we founded the Coalition for Genetic Fairness almost a dozen years ago, it was with the hope that we could organize the many organizations that were disparately working on genetic discrimination legislation together into one cohesive force to coordinate our efforts and advance the legislation through the Congress. Little did we imagine the roller coaster journey we would have been on for the last dozen years, but little did we also imagine the strong new law that would emerge as a result of the combined efforts of so many people, both in government and in the private sector. I'm particularly excited to be here today. For as many of you may remember, particularly early on, there was a question as to whether employment would even be covered by a genetic discrimination law. And as an employee rights advocate, it's been particularly exciting to have watched the Congress pass and the President sign a very strong employment provision section of GINA with very strong protections for employees. In fact, with GINA, this is really the first time when we've looked at really all the discrimination laws that have come through Congress over the years, where Congress has passed a discrimination law where the covered protection had not yet become deeply ingrained in the social fabric. This is a really original concept for the Congress to have engaged in, and so I think I'm particularly proud. I think we should all be particularly proud that the Congress had the foresight to pass legislation to prohibit a form of discrimination before it became endemic. Title II of GINA is a relatively common sense law. My hope and expectation is that the regulations under Title II of GINA reflect the intent of Congress that employees enjoy strong protections under the law, not just to protect them from discrimination, but from access to and disclosure of their personal genetic information as well. Under the best of circumstances, as I'm sure you are quite aware, discrimination cases are difficult to prove. Employers are often the only party with access to information supporting a discrimination claim. Indeed, employees are often unaware, let alone able to prove that discrimination has occurred. Preventing access to information that can lead to discrimination is often the best way to ensure that discrimination does not occur in the first place. It is with these thoughts in mind that I hope the regulations address the following. In terms of the acquisition of genetic information in a general sense, GINA prohibits employers from requesting genetic information even in the rare case where it is arguably job-related. Though over the course of many years, it was very difficult for even the best minds to come up with ways are examples of where it might be job-related. Nevertheless, in terms of the Americans with Disabilities Act, for example, this poses a change to the authorized collection of medical information relevant to meeting a reasonable accommodation request. Employers will need to modify their requests for medical information under these circumstances to remain in compliance with GINA. Similarly, under the ADA, there is virtually no limit to the scope of post-conditional offer of employment medical evaluations, given that most individuals' medical files include such things as family history and may even have genetic test information. An employer that requires access to a large amount of information may run afoul of GINA. Employers will have to modify their medical release forms to minimize this risk. Our hope is that the regulations will provide some guidance in this area for both employers and employees. In terms of the exceptions to the rule prohibiting acquisition of genetic information, it is our belief that such exceptions should be interpreted in the strictest sense possible, both to ensure employee privacy and congressional intent. In particular, with regards to the inadvertent acquisition, or so-called water cooler exception. It is clear that this exception protects the employer when an employee spontaneously volunteers their family history. What isn't clear, however, is how this exception applies when an employer begins asking probing questions that may or may not be so innocent. Nor does it specifically address situations where an employer acquires information more broadly where they should know that family history would likely be included. We hope that some guidance can be provided for both employers and employees in these situations. In terms of the exception allowing for acquisition of genetic information where health or genetic services are offered by the employer. Under GINA, employers can ask for genetic information as part of a wellness program as long as it is voluntary, along with other requirements. It is unclear, however, at what point the voluntary requirement is actually met. Can an employer condition participation in a voluntary wellness program on completing an often standard health questionnaire, including questions regarding family history? Or must the employer allow participation in a voluntary wellness program for an employee who refuses to complete elements of the questionnaire dealing with potential genetic information? Additionally, as Susanna mentioned, there's been much discussion regarding the HIPAA non-discrimination rules, which currently permit a great deal of discrimination based on health status. It is our hope that the EEOC will consider whether such wellness programs currently authorized under HIPAA qualify as voluntary wellness programs under federal employment law, and how this rule intersects with this exception. Furthermore, it is our hope that the regulations provide guidance as to when such programs are governed by Title I as opposed to Title II. In terms of the exception for acquisition of genetic information relating to monitoring for toxic exposure, some employers have programs which conduct genetic tests of workers in specific hazardous environments to determine if they need to be reassigned before symptoms of adverse effects even appear. Such genetic monitoring programs are allowed under GINA. However, GINA makes an important change in the law on this subject. Currently, employers can require employees to be tested. Under GINA, participation is voluntary, along with other requirements. If an employee wants to keep working in a potentially hazardous area, perhaps because of a pay differential, can the employer force him to submit, can the employer transfer the employee to another part of the facility? And if so, under what conditions? In terms of disclosure, GINA permits disclosure of genetic information in response to a court order along with other requirements. A general reading of this language would prohibit disclosure for related procedures such as subpoenas and discovery requests. Will the regulations make this distinction clear? And finally, in terms of construction, what, if any, steps will the regulations take to further refine the firewall between Titles I and II of GINA? In particular, how directed action by an employer in relation to the issuance of their health insurance program will be attended to by GINA. Thank you again, and I welcome any questions you may have.
Mr. Gruber, thank you very much. I'm going to turn to questions starting with the acting vice chair.
Thank you, everyone. This was really great, and I'm given what you've all said, I'm really looking forward to what you have to say after you see the regulations. One of the things this is for all of you, because it's something that you've all said in some way in your testimony and remarks, has been around the need for us to make sure that there are clear examples of things in our regulations. And I think we grapple with this sometimes when we're writing regs, no matter what the regs are. You know, how much to put in the regs versus guidance or an appendix. And if people could speak to that, because I've become of the mind that maybe examples right in the regs are useful. And I want to hear what you have to say about that. Anyone?
Well, I'm happy to step up to the plate here because they are.
Just say who you are.
Yes, I'm Karen Elliott. Thank you. And as a practitioner, the regs live on my desk. They're annotated, they're underlined, and they are the go-to source. As you are familiar, the law is an outline. And the regs fill in the details of that outline and are very critical for guidance as counsel. There's a lot of, a lot of what we do is, what employers want to know is what should they do. They want to stay out of court, they want to do the right thing by their employee, but they also want to be able to run their business effectively and efficiently. They don't need a lawyer saying, well, maybe this, maybe that. They want an answer. They want a yes. They want to know. They want to know if they can go forward. And those examples are exceedingly comforting as counsel to be able to say, well, the regulation says this. Here is the regulation. Follow this. And as long as you stay within the parameters of this example, then you should be good to go. And that helps everybody.
Yeah, I agree with that. This is Ray Van from EEOC, particularly when you're talking about an area that not a whole lot of people have the depth of expertise on. I don't know a whole lot about genetics and genetic testing and things like that from a technical aspect. And new terms, new concepts can be quite intimidating to first-line supervisors, managers, people who are having to make decisions right on the spot. So to the extent that the EEOC, with all of the knowledge and expertise that it brings to the table, can provide some real-world examples of how particular aspects of the law would play out and how they should be dealt with by the employers, I think that would be very helpful.